I'm delighted to be moderating this webinar today on construction arbitration, organized by CAM in conjunction with FTI Consulting, Allen and Gledhill, the Singapore International Arbitration Center, SIArb, and Society of Construction Law. We have some fantastic speakers and some good friends with us today. Dinesh Dhillon from Allen and Gledhill, Singapore. He's co-head of the firm's international arbitration practice. He has acted as lead counsel in international arbitrations for global multinational corporations in various sectors and industries and represented foreign states in international arbitration cases. He's also a litigator, having represented clients in various landmark cases before the Singapore court, and we welcome the international perspective that Dinesh will bring in relation to construction disputes and arbitration. Lee Baker is a managing director of FTI Consulting. He has nearly 20 years of extensive international experience in high-value mega projects across a wide range of industry sectors. Lee has had multiple appointments as an expert witness and has testified in the Singapore High Court. Given the subject of today's session, he's the linchpin in establishing that the delay could never have been caused by the clients we represent, and that they are entitled to cost escalation or liquidated damages or not, depending on whether they are the claimants or respondents. Kevin Nash is the Deputy Registrar and Center Director at SIAC. He's worked at one of Canada's prominent seven sister law firms, completed his LLM in international commercial arbitration, and is also qualified as a barrister and solicitor with the Law Society of Upper Canada. Kevin assists in the administration of all cases filed with SIAC and in the supervision of SIAC's multinational secretariat. Given that SIAC is the most popular arbitral institution for India-centric disputes, and indeed within the region, I'm keen to hear Kevin's views from an institutional perspective. Which brings me to Zubin Behram Kamdin, a good friend, counsel, and also an arbitrator. Over the last 25 years, we have done several cases together. Zubin has practiced and appeared in the Bombay High Court, Supreme Court of India, as well as before various statutory tribunals and in arbitration. He has represented clients in large cross-border construction disputes, and that makes him well placed to share his insights with us on the various issues that arise today. Infrastructure and the construction industry have been big drivers of India's economy. For instance, in FY 2021, infrastructure activities accounted for a 13% share of the total FDI inflows of about 82 billion. This year's Indian budget gave a huge impetus to infrastructure development, allocating 34.5% more than last year to this sector. As projects get larger and more complex, and as investment increases, disputes also become more common, complex, and contentious as the stakes are larger and larger. Enter the pandemic, which gave a toss-up to the best laid plans of mice and men. Although arbitration is a form of alternate dispute resolution, it has become the preferred mode of resolution for all commercial contracts in India and is also the norm globally in the infrastructure sector. Construction disputes are often complex, with voluminous documentation, including highly technical drawings, specifications, project schedules, method statements, bills of quantities, etc. Disputes that arise can involve very specific claims relating to delay, disruption, extensions of time, all of which entail the use of sophisticated methods for assessment and quantification, frequently by the use of expert evidence. Given that there are several moving parts, employers, consultants, contractors, and subcontractors, assigning responsibility for delay, defects, and therefore liability for claims becomes an onerous and unique process. In today's webinar, we will discuss several topics that have a bearing on construction disputes and arbitration, such as multi-tiered dispute resolution clauses, some contractual terms that are characteristic of construction contracts, the kind of disputes that arise and typical claims and defenses that are made, and of course, the issues of assessment of delay and quantification of damages. Our panelists will be discussing these relevant topics from different and unique vantage points from the perspective of counsel, international and domestic, independent experts, and also the arbitral institution. And with that, let me start with the first topic, which is the multi-tiered dispute resolution clause. Now, most construction contracts today have a formal or semi-formal multi-tiered dispute resolution process, where mediation or even a dispute adjudication board is mandated. A mediation, of course, forces the parties to consider a commercial and practical settlement as opposed to the adversarial arbitration that would otherwise ensue. This works particularly well if the project is still ongoing and parties are keen to retain a good relationship. A dispute adjudication or resolution board comprises of a panel of neutral members appointed either for the entirety of the contract or from time to time as and when a dispute arises. These decisions, which are not binding and can aid resolution by virtue of the DAB having indicated by its decision the merits of each party's case, can certainly assist. In the Indian context, however, experientially, we find that the DAB is often used only as a stepping stone to arbitration and almost a tick box before you start. So coming first to Dinesh, are multi-tiered dispute resolution clauses common in international construction arbitration? And what kind of pre-arbitration dispute resolution mechanisms have you commonly seen?
Well, basically, I think that multi-tier clauses are generally quite common. Before I talk specifically about them in the construction context, let me briefly talk about them in what we know to be the general commercial context. And for reasons I'll say, in the general commercial context, I'm less of a fan of them. Generally, these contracts are sometimes referred to as escalation clauses or step clauses. They may require parties to mediate or sometimes to even meet directly with senior people from the company before you can have the right for arbitration to continue. The problem with that sometimes is that all is well and fine, always when you are writing the clause, when you are at the beginnings of your agreement. But when you're in a dispute, they often become an obstruction. They become like a basis for jurisdictional challenges. People start to wonder, what does it mean? Exactly how ambiguous it is or not. So the certainty of the clause is very important. So in that general commercial context, I have reservations because I feel at the end of the day, if a parties genuinely want to mediate, even in the absence of the clause, they can. They can do it anytime. Nothing's to stop them. It's a two hands to clap sort of arrangement. Now, but in construction, I'm actually a bigger fan, especially in the context of dispute adjudication boards and so on, as what you mentioned, because the whole landscape there is we're talking about a situation where the project is ongoing. You want to have a quick fix, a way that we can come to a resolution, but one that you know, if you're not happy with it, isn't necessarily final. And that's where arbitration still plays a part. So it gives the parties the comfort to go on, to have it resolved for the sake of completion of the project and not a distraction. And then you come back to it in arbitration if you have to. And the kind we see there, I think the most common kind is I see is the FIDEC standard form of contracts situation, where the arbitration really sits at the apex of a multi-tiered dispute resolution scheme of the contract. The most basic tier of dispute resolution scheme provides for the submission of a claim, firstly maybe to an engineer, and then the engineer makes a determination of the matter. And if there's dissatisfaction, it then can go to the board. And it's a tiered process. After that, it can go for proper arbitration, but not at the expense of the continuity of the project at least. Now, the other thing that we sometimes see, and this is a feature that actually the SIAC deserves some credit for, in 2015, we had the ARB-MET-ARB protocol launched. And I think that plays an unusual role, a very helpful role in the international landscape, depending if you're a signatory to the New York Convention, because always you're concerned about enforcement in the international context. So in ARB-MET-ARB, you don't really tier it such that the arbitration doesn't start first. You actually get to start your arbitration first, but then it's stayed. And for 8 weeks, you then go for this first tier of mediation. If it fails, you go back to your arbitration and you continue. But if it succeeds, whatever you've settled gets confirmed in the form of an award, which you can have the benefit of the enforcement bite of the New York Convention as well. And coming back to what I said at the start, my biggest concern about commercial contracts that have tiered clauses is that, like for example, in Singapore, there's a Court of Appeal decision, Lufthansa. In that decision, the court has decided to take very literally that when you're supposed to comply with ABC, CEO must meet CEO, before you go for the arbitration, it has to be followed to the T, or the tribunal's jurisdiction may be in doubt. That can be controversial. On one level, you can see the wisdom of it to be certain, but on another level, there could be critics who say, but if it wasn't the CEO meeting, maybe they've implicitly waived it. We should get on with it. So these uncertainties can play out quite differently in different jurisdictions. Different courts may interpret it differently. Court of a seat may interpret it differently from the Court of Enforcement. It's a recipe for problems, and that's why I come back to, if you want to do it, ArbMetArb is a way where you have a tried and tested clause. You go to the model template. It's there for you to use if you really want to do mediation before, and it's been tried and tested. It's certain enough. And I'll pause there.
Thanks, Dinesh. So, of course, the Lufthansa judgment you referred to had a very detailed and very specific pre-arbitration condition that was required to be met.
Yes.
And I understand that Singapore construed that clause as being strictly enforceable. In India, these clauses, if they are not as specific, I would put a caveat there, are deemed to be really directory and not mandatory, and in any event would not preclude a party seeking interim relief prior to invocation of arbitration. But Kevin, I'd be interested to know from the institutional perspective and SIAC's perspective, particularly keeping Singapore law and the Lufthansa judgment in mind. How strictly will an institution look at a multi-tier clause? Is it something that for SIAC the court or the secretariat looks at, or is it left to the tribunal to decide whether the conditions have been met or could have been waived? And would non-compliance render the tribunal without jurisdiction or the claim inadmissible?
Thanks. Thank you, Shanine, and thank you for the invitation. I'm going to borrow from the president of the SIAC Court of Arbitration, Gary Bourne, and from one of our great SIAC counsel, Chahat Chawla, and say that these pre-arbitral steps are a dismal swamp, potentially, or at the very least, muddy waters. And Shanine, as you would know as a member of the SIAC court, it's the SIAC court that is going to be determining the prima facie jurisdictional objections. I'm also going to quite intentionally leave to one side whether this goes to jurisdiction, admissibility, or procedure, and try to give an idea of how it functions from an institutional standpoint. So say, unlike an institution in investment arbitration like ICSID, we don't have a registration requirement. So if there are these preconditions that are put out with specificity, a party can file, and as long as they're in compliance with Rule 3 of the SIAC rules, then we are accepting the case, we are commencing the case. Now, what will happen is if there are these preconditions, the other side may say that there hasn't been compliance with these preconditions. So we're raising an objection to the competence of SIAC to administer this arbitration, or we're objecting, or that the arbitral procedure has not been in accordance with the agreement of the parties. And so with many things in our business, it is going to depend on the language of the clause. So from our standpoint, and we have to think about the prima facie standard, where is that bar for the prima facie standard? So if you had, say, in the Singapore context, following the decision in Lufthansa and its progeny, say it was something that the parties agreed to engage in good faith negotiations. We'll particularly see this with parties from civil law jurisdictions. So what exactly is that good faith negotiations? If the time period is not specific, then from an institutional standpoint, if the respondent says, well, the claimant never engaged in good faith negotiations, the claimant might say, well, in fact, we did. We sent an email suggesting that we negotiate. You did not respond, and now we're commencing arbitration. Now, as Dinesh said, having seen hundreds or thousands of these clauses and knowing how popular they are, we see that from the Queen Mary survey. that blending these procedures together is popular and there is a time-saving potential. But the question is, when a dispute arises potentially 3 years or 5 years from the time of the transaction, do you want to be bound to this bargain? Now, we know in Singapore, following Lufthansa, that you are going to be, if it's set out with specificity, you are going to have to comply with that time period, and you may end up against the limitation period where you need to commence the arbitration. You need to crystallize the commencement of arbitration. Now, in the construction context, say if there's a DAB or reference to an engineer, we see that and that will make sense. So you've got to be a bit careful when you're drafting the clause, looking at the different laws that may apply, as Dinesh had said, and where you're going to be at in that arbitration. So let's say that the respondent has now raised an issue of whether there has been compliance with these preconditions. One of the good things that we have at SIAC is that the registrar determines whether it's going to go to the court and whether, Shanine, you and the court members are going to decide whether there's been compliance with these preconditions. So if there is an objection that is wholly without merit and is just designed to protract the proceedings and create a jurisdictional phase, we do not have to refer it to the court. My view when I'm making this decision from a secretariat standpoint, this is not a substantive decision on our part. It's the SIAC Court of Arbitration that is deciding the substance of the prima facie jurisdictional objection. For us as the secretariat, we're just determining whether it's within the bounds and it goes to the existence or validity of the arbitration agreement and the competence of SIAC. If it goes to the SIAC court, then the SIAC court will determine and could decide that the arbitration will not proceed. So it is a relatively low bar, and it should be pointed out that this is not something that SIAC can do sua sponte on our own initiative. So that's in contrast to, say, the ICC rules, something that we may be looking at in the current rule revision. So it does require an objection from the respondent. The institution cannot do it on its own initiative. Most of these will end up going to the tribunal rather than being dismissed at the prima facie stage. Often we will see parties asking for oral submissions to the SIAC court. This is not done with oral submissions. It's done on the paper. But if there is legitimately a potential issue with the compliance that could go to the sanctity of the arbitration, and the arbitration should not proceed, this is a useful tool, because you do not want to have to constitute a tribunal, go to that additional expense if there is a prima facie jurisdictional objection with merit. So that's the general process on how we're seeing it at the institution. I would like to thank Dinesh for discussing the ARB-MED-ARB procedure, because that's a very easy way to avoid these problems, because you're starting with arbitration right away. You're crystallizing the date of commencement. You're getting a tribunal constituted. The tribunal is then able to stay the arbitration, go to mediation, and all the benefits thereon. And I think there are very few procedures out there in the dispute resolution world where you have sister institutions like SIAC and the Singapore International Mediation Center that are able to work this process together. I mean, I am an arbitration fundamentalist, but I still think that ARB-MED-ARB is something that parties don't look at enough. It is very useful. Not only, I think that we think that it's very useful for the high value disputes, but for the low value disputes as well. This is something that can be used for the multi-billion-dollar major project dispute, or a relatively small, say, claim on variation orders or delay. And it's something that I think parties should look at and are looking at more. And with that, Shanine, if you have, of course, comments from the SIAC court side, we are the ones briefing you. You are the ones deciding, but I will pass back to you.
Thanks. Now, so you've been seeing, so the ARB-MED-ARB provisions have been more common recently. And of course, we also have the Singapore Mediation Convention, which if you're in an ARB-MED-ARB procedure, you may not need, but to have a mediated settlement enforceable in the same way an award is under the New York Convention, I think that's a brilliant thing. So that might be a fillip for the precursor mediation to arbitration. Thanks. Zubin, I'm going to come to you next. One project will always have multiple contracts. There are employers, contractors, subcontractors, several stakeholders as part of the whole. And construction contracts are distinctly different from commercial contracts in terms of their highly technical and complex nature, and so contain very specific and detailed provisions in relation to scope of work, contractor payments, timelines. So what are some of the key provisions that one can expect to see in construction contracts, whether it is the standard form FIDIC or what is quite common, again, in the Indian context, is the ad hoc bespoke contract?
Thanks, Shaneen, for inviting me, and Cam and all the other partners who have made this event possible today. There are a number of clauses which are specific to construction contracts and very peculiar in nature, but I'll try to deal with only a few of them because we don't have that much time. So the first and the most important clauses which you would find here, and this is not related only to construction contracts, would be jurisdiction and governing law clauses. These obviously would be very, very important because they would lend some certainty to the parties as to what is the jurisdiction if a dispute arises. And it's necessary to have these clauses from the point of view of course, if you're a lawyer who's starting out or drafting the contract, it's very necessary to have these to protect your clients as well as certainty for both sides, actually, so that when there's a dispute, they know which court is going to be dealing with the dispute or which arbitration center or institution is going to be dealing with this. If you don't have a clause like this, you could end up in a lot of trouble. Parties could be put to a tremendous time and costs, as mentioned by my earlier panelists, where they could be just disputing where the dispute is going to be decided, or they could be having a whole host of litigations before they even commence starting the litigation on the main issues. So governing law, of course, as we know, the governing law is the law which actually will govern the merits of the dispute. So it's always good to have that also, especially in international contracts, because it's very possible that you will have parties from different countries. You will have the cause of action maybe in a third country or a fourth country also. So you will have a number of countries, and jurisdiction could be, it's a real maze. For a lawyer, actually, it's heaven because he can argue all kinds of complicated issues in court, and that's his profession. But for the clients, it can be pure hell, because before you start with your disputes on merits, you are stuck on all these other issues of jurisdiction, etc. So that's one important thing, which is your jurisdiction clause and your governing law clause. Obviously, procedure, etc., the procedural law, the theory law, all that would be decided if you have a good, tight jurisdiction and governing law clause. The next kind of clauses which you come across in construction contracts specifically are exclusion contracts or exclusion clauses. Now, an exclusion clause is a term which excludes or limits the liability of a party for a breach which is committed. Without the exclusion clause, obviously the party would be completely and wholly liable for the entire amount of damages for such a breach. So examples of these would be where a clause says that there will be no claim or no compensation payable on account of delays, except on certain grounds specified. Or a clause which says that no damages will be payable if there is a force majeure event. They may provide that, yes, time can be given if there is any delay due to the force majeure event. A cap on the LD amount is another example. Or I have come across contracts which say there will be no claims for consequential losses which can be made by either side. So these are some of the nature of exclusion clauses which one comes across. Then, of course, very, very important is accepted matters. Clauses which provide for accepted matters. Accepted matters are matters which the arbitral tribunal cannot get into. They have no jurisdiction to decide these matters, and they are specifically excluded. In most of such cases where there are accepted matters, there will be another authority appointed, like it may be the superintending engineer, the independent engineer, or any other authority. You can have any number of designations. And that authority will often be the final authority to decide on that particular dispute. So for example, all issues of measurement of work will be decided by the superintending engineer alone, and his decision will be final. That's the kind of clause you may get. And once you have that kind of a clause, the arbitrator really cannot get into that issue. He cannot say the decision of the superintending engineer was incorrect for ABC reason and I overrule it, etc. That makes it final. Of course, our courts have found a way around this in certain cases. And by interpreting the contract, they have said that, okay, if I feel that, or if it is found that the named authority's decision is not really meant to be final, he has authority to decide something, but it's not a final decision, then of course the arbitrator can go into it, and it is the arbitrator's decision which will be the final decision. So it's a question of interpretation. There are certain judgments of our courts saying that. For accepted matters, there is also another curious phenomenon which sometimes takes place, which doesn't really help parties decide their disputes fast. And that is this. You may find that a matter is specifically excluded from arbitration, but it has not been given or delegated to a particular authority to decide. So you are left with a situation where the arbitrator can't get into it, but there is no other authority which can get into it, which means there is scope for one of the parties to argue that this is a matter which goes to the civil court. And that is a real problem, because you will find that the arbitrator or the arbitral tribunal is by and large deciding the whole dispute, but you have this one particular point, etc., which perhaps has to go to court or not. And so that is one of the complications which arises in accepted matters. I have come across these in my experience working on matters. Then, of course, you have the time bar clauses. Now, time bar clauses are basically clauses which say that if a party suffers a loss or damage or gets delayed, it can make a claim for damages or for extra time. But to do that, it has to give a particular notice or take action in a particular time frame. And very often the notices will have to specify what is the damage. The notices will often have to be given within a particular time frame. So from within 2 weeks of the occurrence of the event, the notice has to be given. If such a notice is not given, the claim cannot be gone into and cannot be granted. So these are time bar clauses. You often will find something similar like this in force majeure clauses, where there will be a stipulation saying that if you have suffered due to force majeure within 2 weeks of the occurrence of the event, you have to give a notice, you have to specify, sometimes it will have a lot of details, you have to specify the exact event, you have to specify the loss you have suffered or the time you have wasted, and you have to issue the notice to a specific authority or specific person. And the last thing I'll get to, I think, because I've spent quite some time, are fixed price contracts. Now, once again, this is specific to construction contracts. You will often find there are lump sum contracts for large projects. Obviously, this is because the employer would like to have a certainty about the price he's going to pay, and he doesn't want to be told that because of the time constraints or because of the price increasing for various raw products, etc., he has to pay more. So these are lump sum contracts which are entered into. Another variation of that is the lump sum turnkey contract, which is where the project has to be completed right from the designing stage right up to the final stage where it is tested and can actually be commissioned. And the term turnkey comes because the owner is supposed to just walk into the project, and whether it's a factory or it's an oil refinery or whatever it is, he's supposed to just turn the key and the project is to start. And he pays a lump sum for that entire amount, for the entire project from start to finish. So these are some of the main clauses which you can come across in construction contracts.
Thanks, Zubin. Dinesh, coming back to you, in the light of these very characteristic terms in construction contracts, what are the common claims and disputes that you can expect to see?
I think first and foremost, what we always often see are firstly variation claims. These are claims for additional payments and could branch off as well to extension of time claims. And in terms of defenses to these claims, typically one of the starting points would be what is the scope in the contract to vary in the first place. Is it provided for? And if it's provided for, what are the requirements you must meet in order to validly lodge a variation claim? Typically, there will be a notice requirement and it will be strict. So you really need to manage your processes well to make sure that you don't run against defenses that will say you have not complied with these things. And flowing from variation claims comes the valuation of these claims. And how do you value them? So there are several bases of valuation. One approach would be something that is sometimes seen in contracts is a fair or reasonable sum, language to that effect. Now, you need to bear in mind, though, that this can lead to some uncertainty. Very often, what is fair and reasonable, when you're already 4 years down the road and in the contract, the bargaining power has changed. Commercial leverage may have changed. The contractor may be in a more favorable position and so on. So the language is by its very nature somewhat subjective, fair, reasonable. I think litigators can do a lot with such language. So the second approach could be cost plus basis. This is often seen and gives to greater certainty to some extent because the contractor is essentially reimbursed for his cost, and then there will be a specific 10%, maybe it could be 10 to 30% plus. The dispute here could be what is truly your cost. Everything has to be proven and so on. The other form of valuation that may come into play is what I call price-based valuation, found generally in the most sophisticated construction contracts, where the basis for valuing variations derives from the prices and rates as agreed between the parties at the outset. So this can be compared against fair and reasonable that I mentioned earlier. You're actually finding a reference point based on pricing in the original contract. It works best when it's set out in bills of quantities or schedules and rates that are already in the contract before. The question would naturally come, what if the varied work does not correspond with any of the work which had been priced at the time of the contract? Well, then the rates and prices could be contractually adjusted to take into account the differences in the character of the work and the circumstances under which the varied work is ordered. Now, as I mentioned at the start, going from this part of it that comes with it is what we always call extension of time claims. Usually there's a fixed date of completion. The contractor may need more time. Is it provided for? Is it allowed? On whom does the risk fall, depending on how the contract is drafted? There is one Singapore case that I'll briefly talk about called Crescendas Bionics, a 2019 decision. Here, a developer entered into a letter of intent with the contractor to construct a 7-story multi-user business park. Now, both parties agreed that the LOI was legally binding, and the LOI specified a date of completion and liquidated damages, but it did not include any clause for extension of time. The project was subsequently only certified to be completed after the date of completion. The developer therefore sued the contractor for liquidated damages for the delay in completion, and the contractor argued that since the developer was responsible for the delays to the project and there was no clause for extension of time, time was at large, and accordingly the contract only needed to be completed within a reasonable time. And the court accepted this. So this brings up the issue of acts of prevention by the employer. I won't go on much more, but to just highlight other species of claims that you will see. We often see the defects claim, and we also see the delay claim. Delays basically, and delays and disruptions. And once you're into the realm of defects, delays, you're very much into the world of the expert. And I'll stop there.
Thanks, Dinesh. So talking about delays, at the beginning of the COVID pandemic, as lawyers, we were inundated with calls asking, depending on the position of the client, whether a force majeure clause could be invoked or defended. And the supply chain disruptions and the lockdowns imposed by almost all governments resulted in most ongoing projects encountering some amount of stoppage of work and delay. And since all stakeholders were affected to some degree, what we have seen is that there has been, over the last 2 years, some amount of cooperation and compromise. But I think that claims both by contractors and employers can be expected once the project's finally near completion. And that said, apart from just the consequences of the pandemic, claims that arise out of delay are really de rigueur in construction disputes, particularly in India, where scheduling delays can result from a number of reasons, such as, of course, variation in scope, improper planning, but also things like local agitation, the inability to remove encumbrances for handing over sites. So coming to Lee, which Dinesh very kindly teed me up to, how is delay analyzed and assessed by an expert, and what method is used to ascribe responsibility for delay? How are these claims quantified?
Okay. Thank you, Shanine. Good morning, everybody, and thank you very much for joining us. I think my first point is that it's quite rare to see contracts specifically state methodologies to be used. So it's normally left up to the parties to decide the appropriate methodology. And that brings me to the second point, which some people might find a little bit shocking, but there's no actual agreed authority on these methodologies. We have things like the SCL protocol, the AACEI documents, but these themselves, limit their authority and will only say that they're guidance. So that there's no specific authorities to actually go to. And that leads me to, I suppose, a word of warning from a delay expert's perspective. And that is that a lot of people rely very heavily on progress and program-based methodologies. And I think we need to remember what the program actually is. It's a model. It's a model of what may happen in the future, particularly baseline programs. So these are programs which model future works in a sequence that may happen in the future. And they're usually developed at the beginning of the project, at a time when the parties actually know least about the project. And so the point to remember is that these models have inherent inaccuracies and they have margins of errors. So although as delay analysts, we apply scientific rigors on these models, the results are not always going to be precise. So my tip for getting around this is the tip of common sense. When you have a delay analysis, the answer should really tick that box of common sense. In fact, a really good delay analyst, the answer should almost be obvious. If the story comes through, these are what the delays were, and it feels obvious, that means a good analysis is being done. So use the program as a guide, but don't expressly and strictly rely on that program. In terms of the overall process, delay analysis falls into sort of two categories. We have the prospective delay analysis, which is particularly useful for projects that are ongoing. And this method looks at what the potential future effect of delay is. So if you're in the middle of a project and you get given a variation and you want to know what the potential future effect is, these methodologies are very good. It's excellent as part of a change management process for the parties to agree there and then and deal with the delay at the time. The second form of analysis is retrospective. So that's after, and sometimes quite a long time after the events happened, where we look back with the full benefit of hindsight and work out what has happened. So from a dispute perspective, given that arbitrations and even DABs we're seeing can happen quite a long distance after the events have happened, it's these retrospective analysis methods that should be preferred. Because basically we get to use the benefit of hindsight. We know what has happened. Otherwise we'd end up with theoretical results, and that doesn't help anybody. And I know from an arbitrator's perspective, arbitrators want to know what has happened. They're not interested in theory or anything. They want to know what has happened. So taking those retrospective analysis there's two main forms, and I'll use terminology, but as I said earlier, please don't get hung up on terminology. One of them is called the as planned, as built, and the other one is called the time slice analysis. They're derivations of the same analysis, and their fundamental principle is to look at, this is what the parties plan to happen, this is what has happened, and to compare the two. It's as simple as that, and I think that fits quite well for in terms of causation from a legal perspective. The retrospective analysis also works on something called an effect and cause basis. So what the analysis will do, the analysis will identify what the delay was to the critical activities, and that's the effect. The next step is to look at what the cause is. So what did cause that delay? And that's where there's a little bit of a grey line between the delay expert's role and the legal role, because that's taking the evidence and applying it to the analysis to determine whether the delay can be explained. So to give you an example, yesterday I was looking at a delay to a building, and the critical analysis identified that facade was delayed. So that's a matter of fact. So we now go to the evidence, and we can see that at that time, the contractor was actually asked to put the facade on hold because there were upcoming design changes. So that's how we would then link the two together. But then it becomes a little bit of a matter of fact and a bit of legal argument as to which of the facts the arbitrator should prefer. So that's in general how we look at delays and how we assess causation, but we will step away from liability. That we'll leave that to the lawyers.
Thanks, Lee. I'm going to come back to Dinesh very quickly, just to touch upon another kind of claim really that arises out of delay. As I said, delays are very common, and claims arising out of delay are common. And most construction contracts also include the provision for liquidated damages. So my question really to you, Dinesh, is that firstly, is time always of the essence in a construction contract? And how and when can an employer levy liquidated damages on a contractor?
Yeah, that's quite an interesting and timely topic, because there's been some recent jurisprudence from the UK court as well as the Singapore courts on liquidated damages. Firstly, on time being of the essence, time is generally said to be of the essence if any delay in performance is treated as a breach which goes to the root of the contract. That's typically the terminology used. But what goes to the root often is a matter of contract. It's usually provided for. What is considered to be material time-wise, it should be stipulated. If it's not stipulated, it will gravitate towards the court or the tribunal, saying that variations and extensions can be catered for. Time is not so much of the essence, but and so on. Now, liquidated damages, they are generally compensatory in nature. I mean, generally damages you need to be compensatory in nature, and liquidated damages to do away with the need to prove that. But at the same time, one of the main bars to liquidated damages clauses being enforceable, the traditional bar, is that if it's a penalty. In other words, it's the sum of such a level that it's not a genuine pre-estimate of the loss. Now, those legal principles from the common law perspectives are well known from a famous case in Dunlop Pneumatic. I think many would be familiar with it. But the UK Supreme Court in 2015, in this decision called Cavendish and McDessie, they actually departed a bit from this penalty principle, and they brought in the concept of the legitimate interest test. And they said the penalty must be a secondary obligation flowing from a primary obligation. Question, therefore, from the court's perspective is, does the secondary obligation, the payment of the LD, impose a detriment on the party in breach out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation? So this test, one could say, could allow the court to consider the broader function of the LD beyond that of compensation for loss. Now, On the enforceability of LD clauses, an interesting case also came up in Singapore called Comfort Management. This is a 2020 decision. Here there was a claim by the plaintiff against the defendant for delayed completion of works, and the defendant's defense was that no LDs were imposed on plaintiff upstream. And since the plaintiff suffered no loss due to the delay, the plaintiff cannot recover LDs from the defendant. Now, the High Court here held that whether an LD clause is a penalty is determined at the time that the contract is made. In other words, they were not concerned with the defense that actually you have no true loss and I can prove you have no true loss, because if it was a genuine pre-estimate, we uphold the LD clause, and it was upheld. And I think some learning points can come from that, especially from a drafting perspective and risk management perspective. Now, coming back to the case that I mentioned earlier, there's what I mentioned earlier about there being a recent decision. Now, in Singapore, the traditional position when it comes to the impact of termination on liquidated damages clauses is found in a case called LW Infrastructure. Now, in this case, the contractual completion date lapsed in August 2002, and the subcontract was terminated in May of 2003. Now, subsequently, the works were completed by a replacement subcontractor by August of 2003, and the subcontractor argued that the LD clause did not apply upon termination, but the main contractor argued that the LD would be payable up to the date of termination. Now, the court therefore on this case held that the LD would be payable up to the date of termination as a matter of principle. I call this approach the traditional approach. But there was a recent case, 2019, called Triple Point Technology from the UK. And in this decision, the English Court of Appeal gave a decision. The claimant here was Triple Point, was engaged by a company, PTT, to provide a new software management system for commodities works, and was split into phases. Now, Triple Point completed the first two stages of phase one and was paid. It then demanded payment for other works, although milestones had not been met. A disagreement arose and Triple Point suspended the works. PTT then terminated the contract after contractual completion dates lapsed, and Triple Point argued that the LD clause did not apply upon termination. Now, the employer argued that the LD should be payable up to the date of termination. And pause with me here as I give you what this LD clause said. It's quite important here. It said, if the contractor fails to deliver work within the time specified and the delay has not been introduced by PTT, contractor shall be liable to pay the penalty at a rate of 0.1% of undelivered work per day of delay from due date up to date. And these are the important words, up to the date PTT accepts such work. Now, the Court of Appeal seized on those last few words and said that from this, it would seem that if PTT has not accepted to do the work, the LD will not apply. Now, that was an unusual interpretation, and the Supreme Court actually, in the end, just in 2021, on 16 July, actually, in the UK, reversed it. And they held that the liquidated damages were to be calculated actually up to the date of termination. They said those wordings are only to be read in the sense of up to the date they accept, as if they do accept, then you calculate up to the date they accept, but it doesn't operate as a bar. But I thought I would share this case because thankfully that I feel that it's the right decision by the Supreme Court that is more commercial, more realistic, but it shows you how LD clauses, how you word them, how they can be construed, and so on.
Thanks, Dinesh. So I was going to ask Zubin a question on loss of profit claims, but I think maybe Zubin, I'll ask you to just comment on the slight moving away by Indian courts in terms of having to prove loss, even if LDs have been mandated in the contract, because I think that's an interesting nuance. And then I'm going to ask you whether loss of profit claims are also enforceable.
That's not an interesting nuance. You can have a number of separate talks just on that alone. So the situation is quite different in Indian law. In the first place, ever since the days of Hindustan Construction Company and till today, there is a presumption that in respect of construction contracts, time is not of the essence. That's the first big difference. The second difference and the departure from English law as far as the LD clauses are concerned is that our courts do not go into the aspect of whether an LD clause is a penalty or is a clause in terrorism at all. And there's a reason for that. The reason for that is that the law on damages is codified in sections 73 and 74 of the Indian Contract Act. And the words used in section 73 is reasonable compensation. So the logic is that when the codified law itself has used the words reasonable compensation, then that itself shows that it can never be a penalty. And of course, the court has got various grounds on which the court will go into whether it is reasonable compensation or not. So these are the two largest differences between laws in the UK and in India. At UK, I mean, probably Singapore also. The interpretation of section 74, which is really the clause or the section which states that LD can be imposed, has been rather peculiar in our case or in Indian law. And there are certain principles which have arisen, which I will now specify. The first principle is that to claim LD, it's not enough to just have the clause. The party has to show that it has suffered some damage. The reasoning is very simple, that even if there is an LD clause, if the party has suffered no damage, then it will not be given a windfall and it will not be allowed to claim damages. So the first principle is you have to show that you have suffered some damage. The question of whether that damage can be proved, and when we use the word proved really in Indian law, we mean quantified. The question of whether that damage can be quantified or not is a separate issue. But in the first place, a party must prove that some damage has occurred. So for example, where you have clauses where there is a forfeiture of earnest money, etc., the courts have often said, you have not suffered any damage, or you have not been able to show what damage you have suffered. You have just forfeited some amount. And in those cases, the court has said you have therefore suffered no damage. So even if there is an LD clause, you will not be entitled to 1 rupee. So that is one thing. The next issue which they have, which has been laid down in Indian law very clearly, is that even if there is an LD clause which provides that you don't need to prove or quantify your damages, where damages are quantifiable or provable, you must prove them. Which seems a little strange, but that is what the law has now come down to. And the logic for that, once again, is this, that section 73 talks about reasonable compensation for damage that has actually occurred. And therefore, notwithstanding the fact that there is an LD clause, you must still prove the quantum of your damages. The third principle is this: once you prove what your damages are, if you actually prove that your damages are higher than what is mentioned in the LD clause, then that's your bad luck. Your LD clause is still your upper limit, and you won't get 1 rupee more than that. If you manage to prove something less, then you will get only what you have actually proved. You will not get the full amount of the LD clause. And the last principle is this: you will be allowed to not prove or not quantify your damages only in cases where it is impossible to prove such loss, though the loss has occurred, or where it is very, very difficult to prove such loss. And those are the cases in which the amount mentioned in the LD clause will be taken to be a genuine pre-estimate and could be granted to a party. So as you can see, the law is rather different. I personally feel this is not a happy state of affairs at all. I personally feel it requires a complete overhaul. But as I mentioned to Shani, to get into that would be to get into another completely different area. But this is the law as it stands in India today.
Thanks. Zubin, I'm going to ask you to continue also in relation to loss of profit claims that very often contractors are keen to urge.
Yes, so loss of profits claims and often claims for overheads, etc., also are common claims which are made in construction contracts, especially in India. And they arise in the factual scenario where often there have been delays. So construction contracts here, mainly the issues which arise are delays, who is responsible for the delays, the claims are due to the delays, and occasionally, obviously, where a contract has been terminated. And therefore whether the termination is valid and whether delays would be payable on the ground of wrongful termination. Both these claims are absolutely valid claims. They can be made in India, even if a contract doesn't provide for it, because they would be claims which fall squarely under Section 73. They are damages which arise naturally in the course of the contract because of the breach of the contract. And they are often granted by our courts if they are sufficiently proved. So claims for overheads obviously would, for example, be where a contractor says he has been delayed because of the acts of the owner. He was not responsible for the delay. He's had to stay on for a longer period of time, and therefore the overheads, etc., which he has encountered are much higher, and he's entitled to that. Loss of profits also could be on both grounds, either because of delay, where the contractor will say that, listen, I was stuck on your project. I could have very well gone on to something else and made further profits. Or it could be on the ground of wrongful termination, that you have wrongfully terminated this contract. If I had completed it, I would have had profits amounting to so and so amount, and therefore those should be handed over, paid over. And both these claims, therefore, are often made here and are often granted over here, so long as they are proved properly and satisfied. So the only exception to this would be if there are specific exclusion clauses in the contract which say that such claims could not be made. But otherwise, these claims are often made and are often granted in India.
Thanks, Subin. I'm going to now slightly move on from the disputes and claims really to the mode of arbitration. And of course, historically, Indian parties have been keen to proceed by way of ad hoc arbitration, although institutional arbitration has been the norm globally for several years. After the high-level committee's report, we had some extensive amendments to the Arbitration Act in 2018, where the government has now acknowledged and given a big push for institutional arbitration, because that certainly is way more efficient. And SIAC, in fact, has two offices in India, in Bombay and also in the newly set up Gift City. So I want to ask Kevin, of course, from a general perspective, we know why institutional arbitration can be more efficient. But in the particularly complex field of construction arbitration, and given that the project may still be ongoing, what value add really does an institution give? And what kind of expertise can we expect from SIAC?
Thanks, Shanine. Maybe I'll start with an anecdote. And I think that all of us have that ad hoc arbitration story of the 9-year arbitration or the 11-year arbitration. And I recently had a discussion with someone on a small value case where the arbitrator, who performed very well, had fees, hundreds of thousands of dollars. And I felt bad when I told the person that if that was under the SIAC schedule of fees, it would have been subject to a maximum of 6,250 Singapore dollars. And I think that there is still this perception that ad hoc arbitration is cheaper. I think all equal, it's really not. There are efficiencies to be gained by choosing institutional arbitration. And when you're looking at complicated cases such as will sometimes be found in construction, the advantage of institutions is even more attenuated. And there's a couple of reasons for this. So ad hoc arbitration does work. So but you have to be much more cognizant of the lex arbitrii, and are you going to choose procedural rules on top of that? So will you have Singapore seated UNCITRAL arbitration rules? Okay, but let's think about what is actually happening in a construction dispute and the kind of procedural mechanisms that you might need. Emergency arbitration particularly important. Obviously, very well known in India right now in light of some recent events. But in an emergency arbitration, you may need to make an application to restrain the call on a bond, preservation of evidence, access to a site. There's actually an interesting question of what the interaction of emergency arbitration might be with the DAB in the context of a cooling off period, but we'll leave that for another day. So you have that ready-made at all the institutions, or most of the institutions, emergency arbitration. I heard the discussion on force majeure, and I was struck by how appropriate this is for SIAC's early dismissal of claims and defenses, and we've seen lots of these. And think about how quickly you can get resolution on a case if it just turns on the contours of the force majeure clause. So no facts are in dispute, and it's just a question of whether or not force majeure covers a global pandemic. And because now we've seen some of these force majeure clauses that have been updated in light of SARS from more than a decade ago. So you have this early dismissal procedure specifically codified. We also think, and we've really designed the SIAC rules to cater to construction disputes, and particularly some of those big ticket disputes. And if you look at our SIAC's provisions on multiple contracts and consolidation and joinder, that is not going to be available in most jurisdictions unless the parties agree in the ad hoc context. And multiple contracts in particular, under the SIAC rules, it does not require identity of the parties. And this comes up all the time in construction disputes, because you could have a suite of contracts, say 5 contracts, 10 contracts, and it could be the owner claimant on one side, respondent subcontractor, then subcontractor, and all the way down the line. If there are the necessary connecting factors and the arbitration agreements are compatible, you can collapse all of these cases into a single consolidated arbitration. And this will once again be Shaneen and the SIAC court that is deciding this application for consolidation. And same thing with the joinder of additional parties, obviously with cases such as chloral controls in India, the ability to bring in the doctrine to join non-signatories can be particularly important in construction disputes. And I guess finally, it's just the overall supervision and administration by the institution, whether it's a $5,000 case or a $5 billion case, and particularly at SIAC, we are there to make the arbitration go faster, more efficiently, be cost effective. And in ad hoc arbitration, it can be difficult. And one of the most common examples is a situation where the parties are waiting for an award. So you as a claimant that is confident in your case, say the closing submissions have been 4 months ago or 6 months ago, do you want to be chasing the tribunal while it's deciding the merits of the dispute? And that's where the institution is very helpful, that we are able to liaise with the tribunal and the parties. Ad hoc arbitration works very well when all the parties are cooperating. But anytime there are some procedural challenges, that's where institutional arbitration really shows its value. And it's heartening to see how India really is moving to institutional arbitration, particularly for international arbitration after a long time with ad hoc arbitration.
Thanks, Kevin. So I have a story on that. So in an arbitration that I had done with SIAC, in fact, a couple of years ago, we were the claimants. We were ultimately successful, and we expected to be. We were waiting. We were keen to get the award, and SIAC kept us updated, including on the time that it had received the draft award. And we knew that. So one more point to talk about in terms of an arbitral institution is the scrutiny of the award, which I think can become particularly important in a construction dispute, exactly as you said, Kevin, when there are so many stakeholders, so many different kinds of claims and so much evidence. I mean, just the sheer documentation is huge. So to have scrutiny over the award, just to make sure that, you know, things have not been completely missed, because in the last several years, as courts have, you know, the Singapore court is famously pro-arbitration. I think Indian courts have become progressively more pro-arbitration over the years, but that has not stopped the number of challenges to an award. So you want to be sure that any award that you get is well written, reasonably expressed, so that the scope of the challenge or any chance of it being set aside is minimal. So I'm glad for the government's push to institutional arbitration from the Indian perspective. And talking about institutional arbitration, what we've also been seeing, and I'm going to come to Lee now, is more and more the use of independent experts, particularly in construction arbitrations, where previously we would see the line manager or the project manager or the promoter's uncle who was a statutory auditor giving evidence on the client's behalf. But it's become more and more common now to have an independent expert, and there's a huge amount of value add that an independent person who is an expert in this field can add. So Lee, can you tell me what you've been seeing and what really is the value that you bring to the table?
Yeah, thank you. I think the key word is independence that you've mentioned. So the premise is it's quite simple, and this may surprise some people, is that even though the expert is paid for by one of the parties, their duty is to the tribunal. The duty is not to the party who pays them, the duty is to the tribunal. And that's where our credibility comes from. So it means that we can give our opinions, having reviewed the information and actually having turned our mind to it free of inference, and be able to advise the tribunal how we see certain matters. And I think that's key to credibility. We bring that objectivity as well that perhaps site staff don't. And that's not a criticism, but sometimes when you live and breathe the project, you get very blindsided. We have a phrase, sometimes you can't see the wood for the trees. Yeah, you become very obsessed with certain events and you forget the overall picture, whereas as independent experts we can come in and we can see the overall picture. There is, I'm sure, a lot of people there who would be very keen or perhaps would think that there would be an advantage of getting an expert in who would just give them the answers that they want to hear. We would refer to these people as hired guns, and the temptation to have these people would be great. But I promise you, I promise the audience that when it comes to the oral hearing, things will fall down very, very quickly. The lack of independence really undermines any kind of evidence that will be given, and the arbitrator is basically going to be left without one party's evidence. And skilled, it must be holiday time for skilled counsel when they have a hired gun expert coming up in front of them. And the great thing is that I'll be honest, I have no sympathy for parties who do this, parties who knowingly hire hired gun experts. There is a little bit of schadenfreude when their expert gets destroyed on the stand, knowing that it's cost them hundreds of millions of rupees, and you can just see it just slowly fluttering away. A couple of quick points I'd also like to make is that to really take advantage of independent experts, I really do recommend getting experts in early. So, and that's one of the things that we're seeing quite a lot now, is particularly in the delay space, is parties asking us to come in early and produce independent reports on the case as it stands at the moment. And that's really helpful because, first of all, it sort of gives the party a true indication as to where their case is and the potential risks and benefits to proceeding with the dispute. This is something that Justice Coulson, after having given delay experts a bit of a bad time, has actually decided that one of the advantages of delay experts is that we actually act as a bit of a filter, where we come in early. We can actually, we will give you bad news if we have to give you bad news, but it's better that we give you that bad news now than you spend, again, hundreds of millions of rupees, or even not, if not more, to have that bad news delivered in an award. The other advantage I think we provide when we brought in earlier is that we can, if the case does have merit, we can be used as sounding boards by the legal parties to develop the case, to develop the SOC, to identify what the key pieces of evidence are. So in the discovery process, who the key witnesses are, and so we can be used as that sounding board within the realms of independence. The third point I had is that we do bring specific skills. You know, we are. You know, I've been doing this for nearly 20 years. You know, this is what I do. I'm a planning guy, and that's my expertise. And so we've got a lot of experience that we can bring to bear. But also being experts hone certain skills, and one of them, for example, would be attention to detail. As an expert, I have to be able to support pretty much every statement I write in a report, which means that I have to be very comfortable and confident that I've been through the documents and the documents say what I think they say. So I'll give you an example of something that came up just the other day. This is one of my quantum colleagues, that they were looking through the documents and they noticed that the timesheets had been forged. So the other party's case was based upon forged timesheets, but that only became apparent because somebody had actually spent the time going through each individual name on these timesheets to realize that actually they were in two places at the same time, and that there were suspicions should be raised on these timesheets. And the final point, I think, the advantage of an expert, one of the skill sets that I don't think you ever fully accomplish, but you will try as an expert, is the skill of communication. So particularly with delay, delay can be quite complicated, and if you allow it to, it can be very difficult for lay people, anyone, to actually understand what you're saying. So the skill of a good expert is to be able to take what is quite complicated and explain it in quite a simple manner. So those are my 4 key points for the advantages of an independent expert.
Thanks, Lee. I think we're coming to the end of our session, and Dinesh, thank you for answering the question that I was going to put to you anyway, which leads me to a question to Zubin. You talked about accepted matters, and you touched slightly on the problems that would arise if there was no authority before which an accepted matter was supposed to go. So in the case of accepted matters, can the decision of the appointed authority be challenged before the arbitrator? And I'll add to that, if it can be challenged, what is the scope?
So as I mentioned a little briefly when I was dealing with those clauses, whether such a decision could be challenged or not really depends on an interpretation of the contract and the relevant contractual clauses. And our courts have taken a view that where the clauses are very specific and clear, in the sense that they specifically exclude the jurisdiction of the arbitrator or the arbitral tribunal by saying that the arbitral tribunal cannot go into or will not go into so-and-so issue or so-and-so matter. And if there is a clause which specifically provides for another authority to go into that matter, then there is absolutely no doubt on it, because then the courts have said that the tribunal cannot go into it, and the other authority is the final authority, and that is the authority which will decide it, and the arbitrator cannot even sit in judgment on such a decision. The question which arises is that what happens when the clauses are not so clear? And it is in some such cases that our courts have interpreted the clauses to state that, yes, this matter may be decided by so-and-so authority. That's what the clause reads as. But the arbitrator has not been specifically excluded from going into these issues. And in such cases, the courts have, for example, said that because the arbitrator is not specifically excluded, though the authority may have decided on it, the arbitrator also has jurisdiction to go into the issue or to go into whether the authority's decision is correct or not. So it really depends on a reading of the clauses and how the clauses have been phrased, and it's really based on the interpretation of the clauses. And that's when our courts have sometimes come to a conclusion that though there is an authority which can decide these issues, that doesn't necessarily mean that the arbitrator has been barred from going into it. Obviously, to some extent, this is motivated by common sense and a reason that the arbitration must reach fruition, and it doesn't serve any purpose to force parties to have a piecemeal decision, maybe force them to go to court for something and the rest of the issues decided by arbitration, or to make it too piecemeal and say that, okay, there are these 10 different authorities which have decided 10 different issues, and now the arbitrator is left to decide only 1 or 2 points. So to some extent, there's reasons of practicality, etc., which have weighed with the courts, obviously. But this is what the courts have held, that you really have to construct and see what the clauses actually say and interpret the clauses.
Thanks. We're really running out of time, but just one comment, Zubin. Even if the clause is clear and the authority's decision is supposed to be final and binding, would a challenge not be maintainable if the decision is motivated by fraud or corruption, or there has been a failure, for instance, to follow the principles of natural justice, or some egregious omission? So in a very limited set of circumstances, you would still have...
Yes, you're absolutely right on that. You're absolutely right on that. That of course would follow, but that's not the normal way in which these clauses are construed. But you're right. In exceptional cases, those issues could be gone into.
Thanks. Okay, thanks. I think we're now really out of time, and I think everyone, at least the Indians, want to go for lunch because I can see participants dropping. So it just leaves me to thank all of you. Thank you, all the speakers. Thank you to their organizations, to SIArb and to SCL for joining us as supporting partners. This was a really interesting session. For the participants, if there are any further questions that you do have, I know one has not been answered, but please feel free to write in. And if I cannot answer the questions myself, I will take the liberty of passing them on to our stellar speakers. So thank you. Thank you very much. Thanks for joining us, and have a good weekend.